Good morning and welcome to the Supreme Court of the United Kingdom. Today we are in the second day of an appeal by Her Majesty's Commissioners of Revenue and Customs and William Tinkler. The appeal concerns a question of estoppel by convention, and we are hearing the submissions on behalf of the respondent taxpayer from Mr. Thank you.
Good morning, my lord. Good morning, my ladies. I was just about to start at the end of yesterday on a supplementary element of the assumption of responsibility argument, and this is whether or not it could be properly said that Mr. Tinkler assumed responsibility for an assumption that he would not take any defence which might be open to him. And to put this in a context, assume that an officer of the Commissioners writes to a taxpayer's agents and tells them, I have served your client with a notice which complies with Section 9A of the Taxes Management Act 1970. Assume he spells out what the consequences of that are. This means, he says, that you must now give me any information I demand, and your client can't amend his tax return, but it may lead to subsequent proceedings in which I amend your client's return, which you can then appeal. And the agent writes back and says, well, we were about to amend the return. You tell us we can't, but would you please allow us to do so? And the officer says, no, I won't. Is it right in those circumstances for the Commissioners to be able to assert, when it subsequently transpires, that there was a defect in the manner of service, that because the agents asked the officer for permission to amend and were refused, this means the taxpayer is stopped from defending those proceedings on the basis there was a defect in service? And in my respectful submission, the answer is surely not, and yet that is what is argued against Mr. Tinkler here. It must, in my submission, remain open to the taxpayer to rely on the defences afforded to him by statute when it turns out, in particular, that the officer has failed to inform the agents of the full circumstances relating to the manner of service. And if there is an assumption that some form of service has been effected, it does not follow that there is also an assumption that that complied with the statutory requirements. Because the taxpayer may reasonably and cautiously decide that it would be prudent to do what the officer demands, if only because what he is being asked for is in itself uncontroversial. Leaving all else on one side, no one ever suggested to Mr. Tinkler, or sorry, to the Commissioners, but Mr. Tinkler would not argue that what the Commissioners had done was defective, if it were possible for him to so argue. And this is a point which was made by Lord Steen in the Indian endurance case. That was a case where proceedings to recover a small amount of damages were commenced in Cochin. And in discussions, the defendants were informed that proceedings would also be brought in London to recover a much larger sum. And the defendants accepted this would be the case, but failed to object that such proceedings would be defective on the ground of issue estoppel, or under Section 34 of the Civil Jurisdiction and Judgments Act of 1982. And in due course, they accepted service in London, and then they raised the plea of issue estoppel. And the argument for the plaintiffs was that the defendants were estopped by convention because the Cochin proceedings were conducted on the basis the proceedings would not prejudice the plaintiff's right to trial on the merits in London. And at first instance, Mr. Justice Clark held that the defendants were so estopped. And at page 1224 of the bundle, one can see the basis on which he did that. It's between letters E and G. A manifestation of consent to the basis on which the proceedings in Cochin were proceeding, namely that they were limited to the small claim and would not cover the much larger claim to be brought in London. And Lord Steen then continues in that paragraph, but in order to establish an estoppel by convention, the plaintiffs had to prove that the defendants, by their conduct, evinced that they were content that the taking of a judgment in Cochin would not prejudice the resolution of other proceedings on their merits, That is, that in future proceedings, no plea or defence on the basis of a judgment in Cochin would be raised whatever the outcome of the proceedings in Cochin. And over the page, between letters B and C, in considering whether estoppel by convention applied to the facts, he says, the evidence shows merely that the plaintiff's solicitors informed the defendants there would be English proceedings. It falls markedly short of establishing a common assumption manifested by the exchanges between the parties that no plea arising from the fact of the judgment would be taken in the English proceedings. And then down the page at letter E, he says, the evidence does not begin to show that the defendants evinced an attitude. They were content that judgment should be given in Cochin, and that whatever the outcome of the proceedings in Cochin, they would not raise a plea or defence elsewhere on the basis of the fact of a judgment in Cochin. There was no evidence to warrant such a finding. And we say that's analogous to the position here, because here the officer tells BDO that inquiries have been opened, which is analogous, I say, to being told that there would be English proceedings. And there's then a complete absence of vindication on the part of BDO that Mr. Tinkler would not raise a plea or defence based on the failure properly to launch those proceedings. And we say, therefore, that if there were a common assumption, which the commissioners, the problem that the commissioners face, is that that assumption did not involve an expectation or representation by or on behalf of Mr. Tinkler, that he would waive any defence which might be open to him. And in particular, a defence on the basis that what the officer had done failed to conform with the requirements of the statute. Those are my submissions on assumption of responsibility, and I turn then to reliance. And this is the third and fourth conditions, which have to be satisfied on the bench dollar criteria at page 1244. The third being in paragraph 52 that the person alleging the estoppel must in fact have relied upon the common assumption. My lady.
Yes, are you going to deal with the point that you made in paragraph 101 of your case, which we were discussing with Mr. Gammy yesterday, about the attribution of BDO's communication to HMRC to Mr. Tinkler, given the findings which are not now contested that BDO had no actual apparent authority to accept receipt of the notice on his behalf?
My lady, I wasn't. I wasn't going to venture further down that line than that particular paragraph. And then the fourth criterion is that the reliance must have occurred in connection with some subsequent mutual dealing between the parties. And I've already addressed you on that fourth condition, which, for the reasons I've given, I would respectfully submit is better seen as a gateway to the estoppel, rather than simply a condition which was to be proved once the estoppel is being tested. And so far as the third criterion is concerned, we say it was for the commissioners to prove, and they accept this, that they relied on the common assumption rather than merely continuing with their own independent view of the matter. And the way this was expressed by my Lord Briggs in bench dollar at paragraph 55 on that same page is that it was not necessary the revenue should have relied solely or exclusively on the employer's expression of the shared assumption, but only that it should have been a significant part in the revenue's thinking, in the sense of having actively been in the revenue's mind at the time when it decided not to bring immediate protective recovery proceedings. And we say there was simply no evidence before the tribunal that this was so. And if one starts with the question, when did the officer actively consider whether it was necessary to serve a notice of inquiry on Mr. Tinkler and how that should be effected, the answer is shortly before the 1st of July 2005. And if one then goes on to ask, was there any evidence that the officer's mind was in the least bit affected by the letter of 6th of July? The answer is there was none. The commissioners failed to advance any evidence on the point. They didn't raise estoppel by convention until after the close of evidence. And there is absolutely no reason to suppose that what BDO said to the officer made any difference to his thinking. The commissioners failed to call the officer. They failed to refer to the officer's notes or to bring anyone else from his department who had carriage of the matter at the relevant time to give evidence. And looking at the way in which the matter proceeded, we say the officer thought he'd served Mr. Tinkler. He told BDO just as much as that, and BDO accepted what had been said. And when one examines BDO's response to the letter in that letter of the 6th of July, it's wholly unremarkable. It is a response to what the officer has said, and it's not a statement that would have been seized on by the officer as an important or even useful confirmation that he'd impeccably carried out his duties. And of course, one goes back to the letter of the 1st of July. That letter did not ask for confirmation that the notice had had the effect of discharging the officer's obligations under Section 9A, but merely gave BDO information as to what he said he had done. Now, if one contrasts that with the facts of bench dollar, which one can see at page 1233. In that case, the commissioners were concerned by the enormous amount of work which would have been involved in launching thousands of recovery claims in the county court against employers who had been engaged in national insurance contribution mitigation schemes. And they wanted to prevent time running against them under the Limitation Act 1980. So mistakenly, they tried to stop time running by persuading employers to sign acknowledgements of the claim rather than acknowledgements of the debts or liabilities. And the way in which this was done varied, but one type is described at paragraph 11, where the letter written by the revenue is set out. And essentially what it says to the employer is, if you sign this document, then time will stop running and we won't then issue a writ against you. So there was thus mutual advantage to the parties, as the matter was seen by both HMRC and the employers. Neither was going to have to engage in expensive litigation because the expectation was that by this means it would be possible, it would be hoped, to settle the matter without resort to the courts. And so the employers signed because they saw the benefit in their doing so. And the document, which one sees at paragraph 12, expressly indicated that the acknowledgement of the claim was for the purpose of Section 29(5) of the Limitation Act 1980. And then type 2 is to be found at paragraph 14. And there the employer is told that civil action would be launched against them unless a response was received with the signed form, which again referred to Section 29A. And then type 3, which is in paragraph 17, is the case where the progenitors of the transaction was the accountants for the employers in question, involved what was said to be a part payment of £1 in order to start time running afresh, as it was assumed. And at paragraph 54 on page 1244, my Lord Briggs decides that in each case the employers assumed a sufficient degree of responsibility for that shared assumption. They specifically acknowledged that the reason for returning the form was to stop time running under Section 29(5), and sufficiently expressed a desire and intention that the revenue should rely upon that assumption. And HMRC did rely on that assumption in deciding not immediately to issue recovery proceedings. And then at paragraph 55, my Lord concluded that on the plain facts of the case, that acknowledgement was something which the commissioners took into account in deciding not to issue proceedings. No doubt the employers argued that the revenue had made up their own minds that the procedure adopted was adequate to stop time running. But the documentation which passed between the parties indicated that what the commissioners would do if the acknowledgement was not signed and returned was they would issue proceedings. So there was clear evidence that the revenue's thinking in each case was affected by the fact that the employers had very specifically agreed that the relevant steps would indeed stop time running because they didn't issue proceedings. And that was something that employers knew and expected would only happen in the event that they failed to send, in the event that they sent the letter back. That's far removed from this case. In that case, the mutual proceedings between the parties involved an agreement as to the way in which proceedings for the recovery of the NIC would be undertaken, with both parties seeing an advantage to them in finding a solution which prevented them immediately having to move to the issue of proceedings. Each party could see the cost benefits to them in that. In each case, the agreement was that the time bar should be obviated by what turned out to be an ineffectual mechanism. And that was an express part of the deal. And had the employer not acknowledged the effectiveness of the structure as it did by signing the form, the commissioners would have gone ahead and issued the necessary claim. It could therefore clearly be seen that the commissioner's behaviour was dependent on the willingness of the other party to deal on that basis. By contrast, here, the commissioners send a letter to BDO saying that something has happened. And BDO sends a letter back acknowledging receipt of the letter, which tells them that the commissioners have served notice on Mr. Tinkler. Now, assume for the moment that that was all the BDO had said. We acknowledge receipt of your letter. Would that really have made any difference to the commissioner's thinking? Is there evidence, any evidence, that what BDO said would have altered Officer Mackay's perception from what he would have thought? Is there any evidence that the letter as sent was a significant part of the revenue's thinking in the sense of being actively present when it decided not to send another letter? And the initial problem with that is we never reached that stage because there is no evidence that the commissioners ever contemplated sending another letter or adopting another course of action if it failed to obtain an acknowledgement from Mr. Tinkler or BDO. In bench dollar, the commissioners were undoubtedly all set to issue proceedings in those cases where they didn't receive an appropriate response. There is no evidence, and there was no evidence before the tribunal, that Officer Mackay would have carried on sending notices of inquiry out if BDO had simply told him they'd received his letter, and here was the information that he required. Which brings us, I say, to a further flaw in the reasoning of the first-tier tribunal. The judge's decision on the estoppel by convention, and specifically paragraphs 158 onwards at page 212, is based on an assumption that the competition was between BDO telling the commissioners that they had failed to serve Mr. Tinkler and BDO simply not replying. But those were by no means the only possibilities. What, as I say, if BDO had simply acknowledged receipt? Or what if they said nothing at all, but simply sent the information that HMRC had said they'd wanted in that letter of the 1st of July, freely and without being subject to any threats? In those circumstances, BDO would have done nothing wrong. They would not yet have been in breach. They would not have been in breach of some supposed duty to the commissioners. And yet the officer would have been none the wiser, in which case the commissioners would still have failed to satisfy Section 9A. And if one considers whether the form of the letter as sent made any difference, in our submission it did not. It had no more effect, we say, than a mere receipt coupled with the provision of information relating to the Ukrainian properties. So it wasn't the form of BDO's response which led to the commissioners deciding there was no need to serve another notice of inquiry on Mr. Tinkler at some other address of which they would have been unaware. The officer never had any intention of doing that. And the first-tier tribunal dealt with reliance by HMRC at page 211 between paragraphs 149 and 150 at the top of the page. And Judge Mosedale's identification of reliance is, well, first, that the commissioners pursued answers to their questions, including issuing an information notice. Well, perhaps they did, but Officer McKay acted as he did because he had sent the letter to Haybridge Lane, and not because he relied on what BDO had said. And the judge then turned to what she saw as the meat of the commissioner's case. Much more significantly, they did not seek to reissue the inquiry letter. I was not addressed on whether an act of omission counts as well as an act of commission, but in my view, it must do so. It does not matter whether the response was to the shared assumption was inaction or action, as long as it was clearly different to what it would have been had there been no shared mistaken assumption. And she then follows this up at paragraphs 156 to 160 on the following page, considering the commissioner's argument that they would have acted differently within the inquiry window had Mr. Tinkler acted differently. And of course, Mr. Tinkler didn't act at all, but the commissioners rely on what BDO did. And Judge Mosedale's rather difficult reasoning runs in my submission as follows. BDO acted as they did because they had been misled by what the officer said. That's at paragraph 156, where they say BDO acted in reliance on the belief the inquiry was opened, and that belief, of course, was engendered entirely by what the officer had said. The officer acted the way he did because of what BDO did. Had BDO behaved differently, so would HMRC. And HMRC would have pursued the matter had BDO said nothing. And such efforts may well, and note may well, have led Mr. Tinkler being informed there was an open inquiry. And the judge suggests that the chain of causation was broken by BDO responding. And in my submission, that cannot possibly be right. BDO's response was entirely caused by the officer's incorrect assertion that he'd issued a notice in accordance with Section 9A. And the chain of causation therefore leads straight back to that letter of the 1st of July 2005. Now, leaving aside the judge's unwillingness to pay any attention to the fact that all this came about because of what HMRC did and not because of what BDO did, the other problem with this is that in paragraph 157, the predicate for the hypothesis of what HMRC might otherwise have done is absolute silence on the part of those representing Mr. Tinkler and of Mr. Tinkler himself. And here too, the judge's speculation of the outcome of such silence is, in my submission, insufficiently considered. Because what would HMRC have done in that case if they would have done anything at all? Perhaps Officer McKay would have sent the letter again, but he would have sent it again to Haybridge Lane, where it would have sat on the doormat with all the other letters addressed by the officer to Mr. Tinkler. It wouldn't have reached Mr. Tinkler because it would have been sent to the wrong address. And in paragraph 161, Judge Mostale says, I consider it more likely than not that HMRC's original error in sending the notice to the wrong address would have been put right. But why and how? There was no evidence as to what steps HMRC takes in cases where a taxpayer fails to respond to a Section 9A notice. And of course, we're predicating it absolute silence at the moment. And that was something which it was for the commissioners to prove and which they failed to do so. And what the judge did, in my respectful submission, was to speculate without the benefit of evidence. And of course, the judge herself admits its speculation at paragraph 160. This is, of course, speculative, she says. Now, Lord Justice Hamblin identified the errors in this passage in paragraph 71 of his decision on page 161. And he says, The FTT also found that if BDO had not done anything, then it's more likely than not that HMRC's error would have been put right. It is difficult to see how this stands with their earlier speculative conclusion that this may well have led to Mr. Tinkler being informed of the inquiry. In any event, the focus should have been on what BDO did rather than what BDO did not do, and the fact that it played no part in the adoption of the assumption by HMRC. Just so, and I gratefully adopt the learned judge's analysis. And his first point there is the judge seeks to elevate what she admitted was no more than speculation into a finding of fact which was critical to her conclusion. His second point, as he'd already said in paragraph 69 of his judgment, was that BDO did nothing to cause the adoption of the mistaken assumption. The officer had already adopted that as the outset, well before BDO came on the scene, and he had only himself to blame. Officer McKay then misleads BDO into thinking that something is true which was not true, and yet the commissioners now allege that BDO, or rather Mr. Tinkler, should bear full responsibility for their failure to spot the untruth. Which brings me on to unconscionability. And we're back to page 1244 of the bundle. And my Lord,
just before you move on to that, could I just ask you to posit that instead of BDO receiving the communication from HMRC, it was actually Mr. Tinkler himself? Would everything that then went on in terms of communication with HMRC was actually carried out by Mr. Tinkler himself, even though he had not received the valid notice of inquiry? Let's just posit that.
I'm sorry, I thought the first part of the hypothesis was that Mr. Tinkler himself had received the notice from BDO.
No, let's assume exactly the same happened in terms of the notice, but that nevertheless he is in the position of carrying out exactly the same as BDO. So let's assume he's got two addresses and he happens to have got he's at an address where he is communicating with HMRC, and they know that he's there, but they've actually sent the opening of the inquiry, the notice of inquiry, to the wrong address.
Oh, well, it doesn't matter. Although we're calling it the wrong address, the wrong address is code in this case.
The hypothesis.
Yeah. But it doesn't matter which. If Mr. Tinkler had actually received the notice of the 1st of July at any address, he would have been served, and that would be that would satisfy Section 9A, and there would be no more.
I'm asking you to play a hypothetical game here, in a way, where in effect you're putting Mr. Tinkler in the position of BDO directly, and then dealing in the same way as BDO dealt with HMRC. In other words, everything is going on directly with Mr. Tinkler rather than through his agent. Would that make any difference?
Well, I think in order to arrive at that hypothesis, my lord, and this is my difficulty, one would have to change the rules of the Taxes Management Act to say that a notice could only be served on Mr. Tinkler at one of two addresses.
Well, let's assume he just happens to be in the office of BDO at the time when the letters, when the letter arrives from HMRC telling BDO that in fact a notice of inquiry has been sent to his other address.
Then I think if he picks that letter up and he reads it, even though it's a copy, it probably satisfies Section 9A again. I apologize, but one comes round in a circle that there is this difficulty, that it is the very specific facts of this case which lead to the problem that we are in at the moment. And it's very difficult to amend and hypothesize a different set of facts which would likewise cover this particular, which would lead to the same result arising. It's only because Mr. Tinkler never gets the letter at any address that we are here today.
You can't hypothesize of a situation where he would be dealing with HMRC directly rather than through BDO.
No. No, my lord, I don't think one can. So the final bench dollar criterion at page 1244 is that some detriment must thereby have been suffered by the person alleging the estoppel, or benefit thereby have been conferred upon the person alleged to be estopped, sufficient to make it unjust or unconscionable for the latter to assert the true legal or factual position. And an important element of that is thereby. The detriment suffered by the person seeking to rely on the estoppel must have arisen as a result of the operation of the common assumption. It was thus incumbent on the commissioners to prove that they had suffered loss as a result of their reliance on the common assumption, merely rather than by reason of their own officer's independent view of the matter. And as I've already submitted, there was no evidence adduced to support this argument. We simply don't know why the commissioners behaved in the way they did. And I've already said it's highly unlikely the letter of the 6th of July or BDO's willingness to provide information had anything to do with the commissioners' failure to remedy their officers' shortcomings. Officer Mackay did what he did without help from anybody else. And in my respectful submission, the commission has simply failed to make its case on the connection between the alleged common assumption and its susceptibility to Mr. Tinkler's defence under Section 9A. And the second element of the criterion is that the detriment must be sufficient to make it unconscionable for Mr. Tinkler to assert the truth, that the commission has failed to satisfy the statutory requirements of Section 9A. And in that regard, the commissioners say, and they persuaded the first-tier tribunal of this, that the fact that the whole sorry mess was the fault of their officer and had nothing to do with BDO, and most certainly had nothing to do with Mr. Tinkler, was neither here nor there. Their argument is essentially that one can be wholly responsible for a problem and then blame somebody else for it. And that argument was rightly and robustly rejected by the upper tribunal and by the Court of Appeal. I'm putting the matter shortly, without taking you to them, but for your note. We rely on paragraph 67 of the upper tribunal's decision at page 179 of the bundle, and particularly paragraphs 60 to 71 at pages 160 to 161 of Lord Justice Hamblin's decision in the Court of Appeal. And in paragraph 65 of their written case, the commissioners, that's at page 91 of the bundle, advance a number of reasons why it would be unconscionable for Mr. Tinkler to be able to rely on his statutory rights. First, they say, it is regularly the case that the person relying on the estoppel is also the person who initiated it. They rely on what Lord Denning said in Amalgamated Investment, that whether the common assumption was induced by a misrepresentation or not, neither party will be permitted to resolve from it if it would be unfair or unjust to do so. And they also rely on a passage from the judgment of Mr. Justice Goff at first instance in that case. And I've already addressed you on what Lord Denning said, and I took you to Johnson and Gore Wood, where Lord Goff, as by then he was, robustly failed to accept what Lord Denning had said in the Court of Appeal. If one then turns to what Mr. Justice Goff said in Amalgamated Investments at page 667 of the bundle, it was in the context of very different facts from those which we have here. And the relevant facts are set out at paragraphs, if one starts at what he says at paragraph C to D, fourth, by their whole course of conduct, the plaintiffs, and in particular Mr. Foster, represented to the bank and encouraged the bank to believe that the plaintiff's guarantee was binding and effective and covered the Nassau loan, with the effect that after the supplemental deed, the guarantee was secured on charges on real property. The following incidents are particularly relevant as constituting such a course of conduct. And then between D and G, he sets out 6 different sets of facts, all of which supported the reasoning that Mr. Foster had represented and encouraged the bank to believe the guarantee was valid, even though that was a guarantee that the bank itself had created. And the narrative of those transactions really involved the borrower indicating to the bank on a number of different occasions that the guarantee did indeed cover the loans it was seeking. And the result of those representations was that the bank extended a loan facility and affected the deed as security when otherwise it would not have done so. And that's to be seen at 668A to C. And it's because it was encouraged by the conduct that it adopted a course of conduct which was detrimental to his reliance. And at 671, G to 672, Mr. Justice Goff accepts that even if the belief originally came from somewhere else other than from the representor, one has to ask whether that belief was subsequently confirmed by the encouragement or representation of the other. To the extent that his behavior is so influenced by that encouragement or representation that it would be unconscionable for the representor to rely on his strict legal rights. And that's at the top of page 672. So we accept that there may be circumstances in which a wholly innocent error is made by one party who has no more information on the matter than the other party, where the other then develops and influences the assumption made by the first to such an extent that the first may rely on the estoppel created by the later acts of the person sought to be estopped. But that isn't this case. It doesn't follow from the conclusion of Mr. Justice Goff in Amalgamated Investment that in every case where an innocent or indeed a negligent misrepresentation is made by one party which operates on the mind of the other party, the first is then able to stop the second from denying the truth when the truth is eventually revealed. And the other case on which the commissioners rely in this regard is the decision of the Court of Appeal in the Amazonia case, which is, we can pick up at page 780 in the judgment of Lord Justice Staunton. And you'll remember the passage was cited to you by my learned friend just starting below the first break on the first column. And it says, as to unconscionability, it does not seem to me significant who made the first mistake or who had the better opportunity to ascertain the true position. That might seem by itself to support the commissioner's case, but one has to look at the factual matrix in which the statement was made.
Mr. Thomas, if you could give me the page number again.
It's page 780, my lord.
780. Thank you so much.
And one has, as I say, to look at the factual matrix in which the statement was made, and that was that both parties had had plenty of time to consider whether or not they should be submitting a dispute to arbitration. And they jointly decided to proceed on the mistaken basis that this was lawful under Australian law. There's no indication in the judgment that one party misrepresented the position to the other. It was simply suggested by the one that they resort to arbitration, and the other agreed. And indeed, if one has regard to the judgment of Lord Justice Dillon, with whom Lord Justice Mann also agreed, and one sees this at page 784 in the second column, Lord Justice Dillon says If indeed the facts had been, as Mr. Gilmore suggested from the core bundle in opening the appeal, that charterers had out of the blue and without any prior warning delivered a notice of arbitration to disponent owners 3 days before the ultimate time limit under the Hague Rules expired, it would not be difficult to conclude that charterers' loss of their right to bring proceedings within the time limit was entirely their own fault. So the decision was formulated on the basis of an absence of fault in the particular case before them. And it does at least suggest that if the person who seeks to rely on the estoppel was at fault, that would make a very significant difference. And that, we say, is entirely consistent with paragraph 69 of Lord Justice Hambden's decision on page 161. Accordingly, what was said by the Court of Appeal in the Amazonia case cannot apply here, where there was clearly fault on the part of the officer and where the officer failed to provide the necessary information to BDO, which would have enabled BDO to identify the problem. And Judge Mosdale held as much at page 197 in paragraph 83 of her decision, when she decided that the commissioners were on notice that Mr. Tinkler no longer wanted HMRC to send letters to Haybridge Lane. And at page 85, where she holds that the officer had failed to exercise due diligence in deciding which address to send the notice to. And in paragraph 161 on page 212, the judge acknowledges that HMRC were responsible for the mistake, but wrongly discounts that as being irrelevant. That's the second sentence of paragraph 161. Now, addressing the Commissioner's other arguments on unconscionability, which are at page 92 of their written case. First, I refute the suggestion that BDO played their part in the adoption of the assumption. I say their part was that of the innocent Duke, who was never told the critical fact that immediately before the letter was sent, the officer had of his own volition changed the address to which it was sent. And the Commissioners classify that error as innocent misrepresentation in paragraph 66.3. But there is no evidence to support that classification. We don't know why the officer did what he did because he wasn't called. What we do know is that he deliberately caused the address on the TBS system to be changed. And then he sent the letter somewhere he had been told was not the place to which it should be sent. And as I say, the first-tier tribunal found that the Commissioners had been put on notice that Haybridge Lane was not his current residential address, in part because, rightly or wrongly, they had been told in May 2005 that a different address, Winderwath, was. That was in the P60 from the employer. And the first-tier tribunal found the failure of the officer to exercise due diligence. He should have made inquiries and he made none. So the next allegation is that BDO had as much information as the officer. And we say that's entirely without foundation. It wasn't made good in evidence and isn't mentioned in the first-tier tribunal decision. And my Lady Arden yesterday suggested that the process for BDO ought to have been to contact Mr. Tinkler and take instructions. And I would refer you again to that letter from Mr. Jones I showed you yesterday at page 361 of the bundle, in paragraph 3. And what essentially Mr. Jones was saying there was they didn't do that, really, because all they were being asked to do was to answer some questions about the capital gains tax disposals. And so far as needing to take instructions, Mr. Tinkler's evidence before the tribunal was that BDO had been given all the necessary information before the return was submitted. And that's to be found at page 56 of the transcript at line 18 onwards. down to page 57, which is at page 586 of the bundle. If I can just leave you with that reference. There was no evidence before the tribunal that BDO was aware of Mr. Tinkler's residential address. And the contrary is indicated by the documents generated by BDO, all of which were addressed to Station Road. An example of that is the engagement letter at page 218, which you saw yesterday. Apologies, I don't think you did see it. But one sees the address, private and confidential, is to Mr. Tinkler at Station Road. That's the basis on which they were engaged. Another is the Form 64-8, which is the letter notifying the commissioners that BDO were acting as Mr. Tinkler's representatives. Page 231, where Station Road is again given to HMRC as his full address, and I showed you that yesterday. And it's not until late October that the issue of the lost cheque arises, and Officer McKay demands that BDO supply him with a home address. And Mr. Eves says he will phone back with the information in the afternoon, indicating a lack of knowledge on part of BDO. We can see that at page 268. This is the course of telephone conversations and correspondence between pages 266 and 270, to which my learned friend directed you yesterday. And one sees that this is a note of a telephone call from Mr. McKay to Mr. Eves of BDO Stoy Hayward. And in the second paragraph, you see at the end, in any event, I would need to know Tinkler's new private address. So he hasn't been told it by Mr. Eves at that stage. Eves says he'll phone back the afternoon with the required details. And what actually happens, as one sees on page 269, is that BDO fax back on the 31st of October and say, at the foot of that page, with regard to a current correspondence address for Mr. Tinkler, I should be grateful if at present it can be addressed care of the company at Station Road. So again, they failed to provide a home address, but asked McKay to use the Station Road address. So in July 2005, when the issue rears its head, as one would have expected, BDO were in no position to investigate the truth of the assertion made by the officer that, and would not have been able to discern that he'd erroneously used an old address. The commissioners argue that BDO could see that the letter had been sent to Haybridge Lane, that is to say, not to Station Road, and that, they say, should have alerted them to the error. But of course, that's misconceived. No one doubts, and this was the point I was making to Lord Burrows earlier, that the commissioners would have been perfectly entitled to send the letter to Mr. Tinkler's usual or last known address, or any other address at which Mr. Tinkler happened to be residing at the relevant time, though prudently they would sent it to his usual or last known residential address, or to his employment address or his business address, because that gives benefits to the commissioners under section 115(2) of the Taxes Management Act. So merely sending it to an address other than the business address wouldn't, contrary to the commissioner's argument, trigger any suspicions on the part of the accountants. Their reasonable conclusion would be, well, the commissioners know better than we do what Mr. Tinkler's residential address is. And so the Court of Appeal was absolutely right to say in paragraph 65 on page 160 that BDO had no reason to doubt the truth and accuracy of what they were being told by the commissioners. Next, the commissioners argued that Mr. Tinkler suffered no detriment as a result, and if we look at page 93 to see exactly what the argument is. As a result of HMRC's mistake in sending the inquiry letter to Haybridge Lane, that's paragraph 68.4. That is not suffered no detriment as a result of the alleged common assumption, and it's therefore irrelevant to the question of unconscionability. Mr. Tinkler suffered significant detriment from the officer's representation that he'd opened an inquiry. In consequence, the commissioners failed to discharge Mr. Tinkler's claim under the amendment to his self-assessment return until many years later. And he spent the last 9 years fighting the amendment to his self-assessment return made on the basis of that alleged assumption. And he's been obliged to spend a very considerable amount of money in legal fees in bringing his case now before the Supreme Court, some of which fees will undoubtedly be irrecoverable because of that error. Had the officer told the truth, we would not be here. So Mr. Tinkler, we say, undoubtedly suffered detriment in that regard too. I need to deal in rather more detail with the Commissioner's argument on paragraph 68.3 that Mr. Tinkler and or his PA knew of the inquiry from at least November 2005. And the first thing one observes is it isn't in fact an argument that Mr. Tinkler knew. It's only an argument that either Mr. Tinkler or his PA knew. And this requires, I regret to say, to delve back into the history of the proceedings before the first-tier tribunal. The only arguments that the commissioners advanced before counsel made his closing submissions on behalf of the revenue were that BDO were Mr. Tinkler's agents and had received a notice of inquiry themselves, and that sufficed. For the first time in his closing submissions, counsel changed tack and suggested that Mr. Tinkler had received notice by means of his personal assistant, who was, it was argued, his agent for that purpose. But quite rightly, what he never did, having regard to the evidence which had been advanced before the tribunal, was that Mr. Tinkler himself had ever personally received notice or notification of the inquiry. Nor did he ever argue that Mr. Tinkler had been told of the inquiry by his agents. And at page 610, line 22 in page 63, which is the top right-hand page, he did suggest that it was remarkable that no one from BDO nor Mr. Tinkler's PA had been called to give evidence. That's at lines 22 to 24.
Sorry, I'm sorry, are we on a transcript page?
We are. Page 610, top right-hand transcript page. It's page 63 of the transcript. And it's those last lines there. So he suggested it was remarkable that nobody from BDO or PA or the PA had been called to give evidence, but frankly, that was no more than forensic hyperbole, given the way in which the commissioners had limited their pleadings and their skeleton argument to a single argument that BDO were Mr. Tinkler's agents and had received the notice of inquiry themselves, or Mr. Tinkler had received it directly. And that had been the extent of the argument which had to be met. And there was never anything said about Mr. Tinkler having received notification of the inquiry by an alternative means. And if one goes on to the next page, that's the bottom right-hand page on that same page, page 64, line 21, the argument was that Mr. Tinkler could not hide behind his agents and say, I've never been served with this document. But unfortunately for the commissioners, that's precisely what Mr. Tinkler was entitled to do, as the Court of Appeal held, and as the commissioners now admit. It was therefore surprising, to say the least, that when the decision of the first-tier tribunal was issued, it turned out that at paragraphs 55 and 56 of the decision, and one can see those on page 192, the judge had concluded that before BDO actually responded to HMRC in November 2005, either or both Mr. Tinkler and or his PA were told by BDO of the inquiry. Not only was there no evidential basis for this, it wasn't even part of the Commissioner's case. And if one asks what was the basis on which the judge reached that result, the answer is not because she relied on any evidence before her, but simply on her personal speculation, which hadn't been shared by the commissioners, that BDO would have told Mr. Tinkler or his PA what they were doing. But there was no evidence that that was so, and all the evidence was to the contrary. And the tribunal had heard Mr. Tinkler's oral evidence and heard his denial that he had been told of the inquiry. He remembered, and he gave clear evidence of this, that he'd been asked to sign something relating to a check which had gone missing. And the evidence is set out for convenience at paragraphs 52 and 53 and 58 of our written case on pages 114 to 115 of the bundle. And the whole of the evidence is contained in the transcripts at tab 47 in part 2 of the appendix, with the relevant passages being from page 51, line 1, which is on page 585 of the bundle, to page 60, line 5 on page 587 of the bundle. And throughout that evidence, counsel for the commissioners cross-examined Mr. Tinkler on whether he had been told of the inquiry, and he roundly rejected that proposition and said he had not. And I invite you to look at that transcript later if this appears to be a significant issue in your decision. None of this, and there was nothing more, supported the conclusion reached by the judge that Mr. Tinkler or his PA had been told of the inquiry. The evidence, such as it was, went only so far as to establish that Mr. Tinkler was involved in an entirely separate matter relating to the missing check. None of this was argued for by the commissioners. And yet I regret to say that the judge took it upon herself to make findings which even the commissioners' counsel did not invite her to make. It was unfair, I submit, for her to do so without recalling the parties and asking for further evidence on the point, because had she done so, Mr. Tinkler would have called his PA to give evidence and would have called somebody from BDO to give evidence. But he was never given the opportunity, my lord.
Were these points made to the upper tribunal?
They were made in a similar fashion, yes, my lord. I mean, I'm not moving on from a position I've not taken before. This has been the thrust of my argument throughout the upper tribunal and the Court of Appeal to this case in the Supreme Court.
Thank you.
But he was never given the opportunity of doing so. If one goes back to paragraph 56 on page 192, it doesn't amount to very much anyway. The judge was unable to make up her mind whether or not Mr. Tinkler knew. Believing it was unnecessary for her to decide that, she didn't do so. And if one breaks down her conclusion into its logical constituent elements and asks what it was that she did decide, the answers come out as follows. First, did the judge decide that Mr. Tinkler knew? And the answer is no, she didn't. Did the judge decide that Mr. Tinkler's PA knew? And the answer is no, she didn't. And did the judge decide that both Mr. Tinkler and his PA knew? And the answer is no, she didn't. So the result is her answers didn't amount to a positive decision that anyone knew. And indeed, it is somewhat surprising that having decided that Mr. Tinkler might have known when his PA did not, and that his PA might know when Mr. Tinkler did not, the judge didn't complete the logical sequence by concluding that if there were circumstances in which either T or his PA knew nothing, it was an equally valid and frankly far more supportable conclusion that neither of them knew anything. That, we say, was the only right evidence, the only right answer, the only evidence before the first-tier tribunal failed to demonstrate that anybody knew about the supposed inquiry other than BDO and HMRC. The only evidence went to the check. None of the evidence went to the inquiry. The rest was purely speculative on the part of the judge, with the consequence that the judge quite rightly failed to make up her mind on the point, even though it appears from paragraph 56 to come out as a finding of fact. And in any event, would it matter if the PA had known? That wouldn't have amounted to notifying Mr. Tinkler, and that argument has already been lost and not repeated beyond the Court of Appeal. It would have been no different from BDO knowing. And the first tier tribunal never actually found that Mr. Tinkler did know. Because, as I say, if the PA knew, that even then Judge Mosdale was of the view that Mr. Tinkler might not. From which rather lengthy and tedious exposition, I invite you to disregard the very odd finding, since first there was no evidential basis for it, and secondly, the commissioners are unable to prove that Mr. Tinkler knew of the inquiry. And perhaps more importantly than any of that is, why would it matter if he did know? And as Sir Bernard Ricks said in the Court of Argument in the Court of Appeal, even if BDO told Mr. Tinkler that the revenue were inquiring into his tax return, this wouldn't mean that he would have been told that they were purporting to do so under Section 9A, or that that would mean anything to him if they had. He wouldn't know that it was a necessary condition for satisfying Section 9A that he needed personally to be served. So none of this can properly be brought to bear as an argument why it would be unconscionable for Mr. Tinkler to plead estoppel. Indeed, the first tier tribunal did not use this apparent finding as a means of establishing estoppel by convention, but simply in order to show that Mr. Tinkler had been sufficiently informed for Section 9A purposes. And that, of course, is the argument the Commission has now abandoned. And to forestall an argument made in my learned friend's written case, I deny that I'm engaged in some roving selection of evidence coupled with a general assertion that the findings of the judge went against the weight of the evidence. I'm looking at very specific findings here, and my assertion is that there was no evidence to support them whatsoever. You have everything that the judge had. You've got the transcripts of evidence. You've got all the correspondence that was before the tribunal. And the only things that you do not have are large quantities of company returns produced by the commissioners in order to support an argument that went nowhere, that Mr. Tinkler was indeed reasonably to be thought resident at Haybridge Lane. And when one considers the manner in which the judge decided the question of Mr. Tinkler's knowledge in paragraph 56, it's clear that there was no evidence which she was able to identify which supported the finding that Mr. Tinkler knew of the inquiry before the end of the prescribed period. Now, my learned friend's next point is that whether it was unconscionable for Mr. Tinkler to assert his legal rights is a matter best left to the evaluative judgment of the first tier tribunal. And with the very greatest respect to the first tier tribunal, when one considers the speculative decision-making process adopted by the tribunal and the errors of law and fact which the judge made, and what I submit is the judge's failure properly to apply the bench dollar criteria, and where the only relevant evidence on this issue is the correspondence between Officer McKay and BDO, which this court can as readily examine as the first tier tribunal, that is not, in my respectful submission, a realistic proposition. Both the upper tribunal and the Court of Appeal dealt with this in as kindly fashion as they could, but their decision was that the way in which the judge approached this exercise was inappropriate. And deciding whether or not the facts of a case, when properly found, lead to a conclusion of unconscionability is clearly a matter within the jurisdiction of an appellate court. And I would invite you to follow the conclusions of both the upper tribunal and the Court of Appeal. Dealing with the argument that it was perfectly reasonable for the commissioners not to call the officer, I don't blame them for doing that. But like any other litigant who is required to prove their case, their failure to do so, coupled with the way in which they failed to advance their estoppel case until closing submissions, has had the inevitable consequence that they were left without any evidential basis for their argument. The fact that the officer was unwell and unable to give evidence was the risk they took in leaving their alleged inquiry open for 7 years. That is a risk of delayed litigation. But it does not follow that when, in consequence, the relevant witness is no longer available to give evidence, the absence can be made good by speculation. Moving on, if of course BDO had known the notice had not been sent to the right address and had deliberately failed to correct the error, that might possibly be a different case. But even then, one ought to observe the grunt formulation, which one can see at page 158 in Lord Justice Hamblin's judgment, paragraph 55. 158. And one sees right at the bottom, 4 lines up from the bottom, after the dots, or because knowing the mistake the other laboured under, he refrained from correcting him when it was his duty to do so. There may be a debate for another day as to whether a taxpayer has a duty to correct an obvious error on the part of the commissioners. But the commissioners failed to establish that BDO knew of Mr. Tinkler's home address, and BDO had no reason to believe that the address used by the officer on the notice of inquiry was other than Mr. Tinkler's residential address. And the commissioners then boldly argue in paragraph 54 of their case that BDO could have checked with their client whether he'd received the letter. The implication being that they should have done so, and their failure to do so was some form of dereliction of duty on their part. In my respectful submission, it was not. Why should they have checked that with their client? What the officer said to them was that he had issued a notice of inquiry to Mr. Tinkler. They trusted the officer. In retrospect, it turns out as Lord Justice Hamblin said at paragraph 64 on page 160, in the BDO letter, HMRC represented to BDO that an inquiry had been opened by the notice of inquiry sent to Mr. Tinkler in the letter. That statement was false, but it was a representation made by the commissioners on which BDO reasonably relied. So, summing up, if BDO had no duty to correct a misunderstanding on the part of the officer of which they were unaware, and what BDO themselves did not engender a belief or expectation of the necessary kind in the officer's mind, which in my submission it did not, then no criticism can be levelled against Mr. Tinkler when eventually finding out some 7 years later that HMRC had sent a notice of inquiry to the wrong address. He relies on their failure to comply with Section 9A as a full defence to the closure notice. And finally, I've got a couple of additional points raising from issues which arose yesterday, which perhaps I could now deal with, which would then bring my submissions to an end. First of all, contrary to what Mr. Gammy said, there is no evidence that BDO charged for the fees for the work they did in this regard. The letter of 11th of December 2015, that's the letter at page 361 that I've taken you to already today, indicated that BDO saw the work as covered by the original engagement to prepare and answer questions relating to the tax return and of a simple nature. And at page 192 of her decision, Judge Mosdale indicates as much, because one noticed that she says, it's unlikely to me, what seems unlikely to me, this is at line 23 at the bottom of the page, is that BDO would actually deal with the inquiry, even as a matter of goodwill without charging fees, without informing their client. I'm not sure it's an important point, but there it is. Secondly, addressing my Lord Briggs's point yesterday, it might have been possible for the taxpayers in bench dollar to argue that HMRC should have been prevented from relying on estoppel by convention as regards classes 1 and 2, on the basis that a proposition of law which was incorrect was advanced by HMRC and accepted by the employers. It might have been argued, but as I understand it, it wasn't. But there are, in any event, significant differences between that case and this, and they are, in my respectful submission, important differences, which probably would have made all the difference. First of all, there's no evidence that the commissioners kept any information to themselves in bench dollar, whereas here BDO were not given full information by the officer as to what he had done. Secondly, the outcome in bench dollar might have depended on whether or not the misrepresentation operated on the employers, or whether they took their own advice of the matter and decided to engage with the commissioners on the basis of that advice. So maybe there was an argument for the taxpayers to make there, but it wasn't advanced. I mean, next, my Lord Briggs asked whether the BDO's response of the 6th of July fell within the description in Spencer, Bauer and Turner, which is cited at page 1243, where it said, the question is whether the party estopped intended the estoppel raiser to rely on the subscription of the party estopped to the common view. But what I say of that is there was no evidence which could lead a court to find that that was BDO's intention. One may contrast the position here, where there was no benefit to Mr. Tinkler in subscribing to that assumption, with that in bench dollar, where the relevant letters were clearly framed in terms by which the employer specifically acknowledged that the reason for returning the form was to stop time running, and sufficiently expressed a desire that the other party rely on that assumption because there was an immediate benefit in their so doing. Now, Lord Hodge invited me to point to authorities where the need for mutual benefit from the assumption was identified. And I took you to what Chief Justice Latham cited from Lord Justice Scrutton's decision in Verschure Creameries yesterday. And really, it comes to an issue of swings and roundabouts. If you are going to take advantage of an assumption to obtain a benefit, you also have to accept that the other party may equally demand the same treatment by reference to the same assumption. But if one turns the question on its head and asks whether there are any cases in which estoppel by convention has been found to exist where there was no such mutual benefit expected from the adoption of the assumption, in my respectful submission, it is hard to find any. At least I haven't found any. In every case, the parties subscribe to the assumption because it is seen as securing an advantage to them, either immediately or in the future. That's the essence of a mutual dealing. And that's signally absent here. And the clearest example we've been able to find in the cases before you of the importance of mutual benefit is the Indian Endurance case, where in the Court of Appeal, Lord Justice Staunton, at page 1202, between letters F and G, reasons that there's no common assumption because, amongst other things, it's difficult to think of any reason why the owners would wish to agree to the government's assumption. There was no advantage to them in being sued to judgment in two different countries for two parts of the claim. So when I was undertaking an evidential process of trying to work out whether one party should be seen as intending the other to rely on it, why should one assume that to be the case, where the common assumption is disadvantageous to him and advantageous only to the other party? Unless there is an express indication that that is the intention of the parties, in the same way as one can rely on an assumption that is untrue if both parties expressly intend to do so and agree to do so. So in my respectful submission, in the absence of mutual benefit, one ought not to be seeing a subscription to a common assumption. And unless I can assist you further, I would invite you to dismiss the Commissioner's appeal. And those are my submissions.
Lord Burrows has a question.
I'm going to try another hypothesis with you, if I may, a rather different one. Let's assume that HMRC had inquired of BDO. Has Mr. Tinkler received the inquiry notice? And BDO had answered that that was indeed the case. I assume that they would have authority to do that. You're not disputing that there is authority to answer that inquiry, are you? Or are you?
They wouldn't, I'm not sure they would have actual authority.
No,
but I find it very difficult to say they might not have ostensible authority.
Now, might it be therefore said that what we're really being required to decide is whether or not what BDO did was equivalent to that sort of representation, that in fact a valid inquiry had been commenced, a valid notice had been sent. In other words, are we not being asked to decide whether, by implication, that sort of representation has been made?
That certainly is what the commissioners are asking you to do, but in my respectful submission, it's an incorrect exercise. In my submission, one has to take the letter of the 1st of July together and read it together with the letter of 6th of July to see what's happening. And one can't read the letter of 6th of July in vacuo. And taking the two together, it's clear what the effect of the 1st of July is on what happens on the 6th of July letter. They are impressed by what is said by the officer who clearly states, I have served a notice under Section 9A in accordance with the requirement. And he refers to Section 9A. So
I think what I'm putting to you is, I understand that your response would be that there isn't any implied representation of that kind.
Yes.
On these facts.
Yes.
But I'm just trying to get clear in my mind that that's got nothing to do with the authority point, because you're accepting, as I understand the answer to the first question, that there is almost certainly, I think you indicated, apparent authority for BDO to make that sort of representation.
That's why I regrettably ducked Lady Rose's question earlier today, I think.
Thank you very much.
Thank you very much, Mr. Thomas. I think this is an appropriate point to take the 5-minute break, and then we'll resume to hear Mr. Gammey's reply. The court will now adjourn. Mr. Gammey, we are now in a position to resume.
Thank you, my lord. My lords, my ladies, I have a small number of points to make in reply, which I'll make under 5 headings, those being as follows. First, I'll address my learned friend's submissions about this really being an estoppel by representation case and not an estoppel by convention case, with the alleged representation or representations being made by the revenue to Mr. Tinkler. Secondly, I'll address briefly my learned friend's submission that there is no transaction or no mutual dealing of the right type in the present case. Thirdly, I'll address again briefly my learned friend's attempt to rely on Keane and Holland. Fourthly, I'll address certain aspects of my learned friend's submissions on the assumption of responsibility ingredient. And finally, I'll address my learned friend's submissions on the unconscionability ingredient. So taking the first part, the estoppel by representation issue that my learned friend raises. As he says, it's really about this being about a estoppel by representation case. And I have 3 points to make about this. First, this argument relies upon my learned friend persuading you that the revenue made a representation to Mr. Tinkler's agent. My learned friend said that 2 misrepresentations have been made. The first alleged misrepresentation was that Officer Mackay had complied with the requirements of Section 9A. The second alleged misrepresentation was that the consequences of Section 9A arose as a result of what Officer Mackay had done. We say it's impossible to read Officer Mackay's letter to BDO as including any such representations. Everything Officer Mackay said in his letter to BDO the 1st of July was true. If we look at Section 9A of the Management Act, just to see the context, that's at bundle page 633, and we can see what that says. So, subsection 1, an officer of the board may inquire into a return under section 8 or 8A of this act if he gives notice of his intention to do so to the person whose return it is within the time allowed. And that's essentially what it provides. The rest of the section not really adding to that. So Officer Mackay tells BDO that he's providing BDO with, in quotes, the Section 9A TMA 1970 notice, which has today been issued to your client. That was true. Officer Mackay did not say to BDO, I have an open inquiry into Mr. Tinkler's 2003-4 tax return. Please send me the following information. Or, I'm serving you with notice opening an inquiry into Mr. Tinkler's 2003-4 tax return. All he says, and this is at the bundle at page 254, all he says is, I enclose for your information a copy of the Section 9A TMA notice, which has today been issued to your client in respect of his return of income for the year ended 5th April 2004. Enclosed with that letter was the notice that had been issued to Mr. Tinkler. The only representation involved is that Officer Mackay has done what he's said that he's done. In other words, issue a Section 9A notice to Mr. Tinkler, which the first tier tribunal found as a fact that he had indeed done. That, for your note, is the first tier tribunal decision at paragraph 47, which is at page 191 of the bundle. That statement cannot amount to a representation that the Section 9A notice has been given, because that will only be the case when the notice that Officer Mackay has issued to Mr. Tinkler has been received by Mr. Tinkler. Officer Mackay said nothing in the letter about that. Indeed, he could not have said anything about that, because the letter to BDO and the letter to Mr. Tinkler's Haybridge Lane address were both sent on the same day. Section 9A imposes no requirement as to where or how the officer is to give notice of his intention to inquire into the taxpayer's return. Section 9A imposes no requirements as to how the notice is to be addressed or the manner in which it's to be given. The consequence of Officer Mackay's action in addressing the letter to the Haybridge Lane address rather than Station Road is that the revenue cannot rely on Section 115 of the Management Act, compliance with which would have put the matter of whether the notice had been given beyond question. But Officer Mackay makes no representation about that. The copy letter told BDO where the letter had been sent. Whether or not they know Mr. Tinkler's current residential address, they could see that the letter was not addressed to Station Road. And of course it was Station Road with which BDO were familiar. In short, every word of Officer Mackay's letter was true, it cannot fairly be read as including any representation other than that Officer Mackay had done exactly what he said he'd done. The one missing element to the operation of the Section 9A notice, which Officer Mackay cannot know and about which he says nothing, is whether the Section 9A notice that he's issued to Mr. Tinkler has in fact been received by Mr. Tinkler. So that's Officer Mackay's letter, but then BDO reply on the 6th of July 2005, and that's in the bundle at page 258. And they promise to provide the information that Officer Mackay has requested by the 22nd of August, and they notify an amendment to Mr. Tinkler's 2003-4 tax return, but note that this cannot take effect because the return is subject to inquiry. Quite remarkably, my learned friend appeared to suggest yesterday that BDO might have been purporting to amend Mr. Tinkler's tax return without having instructions from him to do so. Even if BDO had overlooked the guilt strip scheme when filing his original return, the taxpayer takes personal responsibility for what is in his tax return. For a well-respected firm such as BDO to amend its client's tax return without any reference to the client, even if only to correct a previous omission, would be quite extraordinary and of considerable concern to its clients. BDO did not have actual or apparent authority to be given the Section 9A notice on Mr. Tinkler's behalf, so their receipt of the copy notice did not perfect the Section 9A notice that Officer Mackay had issued to Mr. Tinkler. But BDO did have actual or apparent authority to act for Mr. Tinkler in any inquiry. That was the effect of the 64.8 notification at page 231 of the bundle, which the BDO had provided to the Revenue in January, on the 12th of January, and the first tier tribunal found that BDO were acting as Mr. Tinkler's authorised agents with both apparent and actual authority in the course of conducting the inquiry. That's the first tier tribunal's decisions at paragraphs 141 to 145. That conclusion has never been disputed and is not open to challenge. Whether or not BDO had communicated with Mr. Tinkler before writing to the Revenue on 6th of July 2005 is neither here nor there. The Revenue were entitled to assume that BDO were acting within the scope of their authority to deal with inquiries as Mr. Tinkler's tax agent. At no point thereafter, within the time allowed for giving a notice of inquiry, did Mr. Tinkler or BDO on his behalf disabuse the Revenue of the fact that Mr. Tinkler had never in fact received the Section 9A notice that Officer Mackay had issued to him on the 1st of July 2005. By the time Mr. Tinkler set the record straight on this, the time for correcting the position had long since passed to the Revenue's prejudice, as the first tier tribunal concluded. So, as I say, the resort to estoppel by representation does not assist Mr. Tinkler at all. There was no such representation in the letter of the 1st of July 2005. My second point on this relates to my learned friend's submission that as a matter of principle, if there has been a representation by the estoppel raiser, so that the representee might set up an estoppel by representation against the maker of the statement, there is no scope for estoppel by convention to arise. In other words, the possibility that there might be an estoppel by representation excludes any convention estoppel that might arise on the same facts. As to this, I say there is no basis for it, either as a matter of authority or as a matter of principle. As a matter of authority, not only is there authority that supports no authority that supports my learned friend's proposition, so no authority that he can cite to support that proposition, but indeed it's positively inconsistent with what Lord Denning said in Amalgamated Investment and the result in bench dollar. In terms of principle, why should the fact that the assumption arose from a representation by one party automatically preclude the convention estoppel? If two parties conduct their mutual dealings on an assumed basis, it should not matter how they came to that mutually assumed basis, provided that it would be unconscionable in all the circumstances for the party to be estopped to resolve from it. The latter point is really the touchstone for the application of the doctrine. My learned friend sought to justify his rather extreme position on this point by contending that if the law were otherwise, then an innocent representee might find himself bound to adhere to an assumption which had arisen by virtue of a negligent misrepresentation made by the estoppel raiser. As my Lord Briggs.
Does not the Grunt case suggest that the analysis of whether or not it's unconscionable for the person alleged to be estopped to assert the truth depends critically on the nature of that person's conduct in the process which led to the arising of the convention between them? Most of the examples which the judge in the Grunt case gives, I think it's page 1334 of the PowerPoint, where he says it's unconscionability isn't just a question of the length of the chancellor's finger. It runs in certain quite well-defined streams, and he then sets them out. Appear to be about the nature of the conduct of the party alleged to be estopped in giving rise to the convention.
Indeed, my lord, yes, I would. When I say I would agree with that, but my learned friend, as I understand his submission, is effectively saying that if that representation is what's led to the common assumption, then there is no room or no space for estoppel by convention. Whereas I would say that that is, how it has arisen, and as you have just illustrated, my lord, the conduct, if you like, of the person who's given rise to the common assumption is a factor to be taken into account in deciding whether or not it's unconscionable for him to resile from that position.
Yeah. I mean, I suppose the second half of my question is, with which of those, what I'm going to call Grunt tests, would you submit that the Mr. Tinkler's or his agent's conduct is to be aligned in this case? Obviously, those tests aren't meant to be a statute, but they were certainly, I think, thought of by the judge in Grunt as covering the ground.
Yes, well, they in terms of how they've responded, I think is what you're considering,
Yes.
on the 6th of July.
Yeah, well, yes, and or November.
And indeed in November, of course, the ongoing response in November being at a point at which the first tier tribunal had concluded that certainly Mr. Tinkler or his personal assistant knew of the ongoing inquiry. That I would have said is, I mean, that leads to the common assumption. It's difficult to see why, when I say that is any, that if you like, the inspector's decision to send a letter to the Haybridge Lane address is in some way more reprehensible, as I think my learned friend would put it, than the part played by BDO in leading to the common assumption that the parties were operating under. I mean, in a sense, we're not talking about exhaustive categories. We're obviously talking about examples and an overall assessment in the light of that as to whether, in fact, the party who's sought to be estopped, whether it's unconscionable for him to resolve from that position.
Yes, thank you.
Does that deal?
I gave you the wrong page number for my question, but I don't think that caused you the difficulty. It's actually rather later in the report. It's at page 1353, I think.
Yes.
Thank you.
I mean, I think the test, of course, my lord, is set out in both Bench Dollar and Blindley Heath, and the question I would say is, has Mr. Tinkler, BDO on it and acting on his behalf, played his part in the adoption of the assumption such that it would be unconscionable for him to resolve from it? That is essentially the assessment that needs to be made. Anyway, just to
Can I just before
yes.
you move on from that?
Yes, Lady.
Does it all just really roll up into unconscionability, or might one say that when you're assessing the letter of the 6th of July, or more generally what's crossing the line from the person now seeking to deny the estoppel, you have to read that in its context as a response to what has come from the person who is now seeking to set up the estoppel. So if there is a representation or something like a representation coming from HMRC in this case, that's relevant to whether one reads the response from the taxpayer as confirming, endorsing, whatever that assumption, or just acknowledging that that's what they've been told, which might fall on the other side of the line. Don't you think that the relevance of whether there's a representation from HMRC helps to construe the nature of what is coming back from the person who's now seeking to deny the estoppel?
Well, my lady, for the reasons I've given, we don't accept that there's a representation in I suppose it depends in what sense you're using that. The revenue, Mr. Mackay and the revenue have told BDO what they have done. And we say that is quite straightforward. BDO have responded to that by essentially confirming their understanding that that there is an inquiry ongoing. That is a state of affairs that continues over a period of time, starting with the 6th of July, but continuing right through until November, when they deal with the inquiries that have been raised, including, of course, the information notice that the revenue sought to issue when they didn't get the information in the first place. So I think there is in that sense, that whole course of conduct that gives rise to the common mistake or assumption under which the parties are labouring. And then I think one has to ask, as I said to my Lord Briggs a few minutes ago, one has to ask whether or not Mr. Tinkler, through his agent, BDO, has played his part in adopting the assumption which makes it unconscionable for him to resile from the position that the parties have been acting under. And I don't know whether that answers satisfactorily your question, my lady.
Yes, thank you.
So
I just ask, while we're on this general topic, whether you would agree with the citation and with approval by Lord Bingham in the Vista Field of a statement by Lord Justice Purchase. It's at 1111 at the bottom right of the page, where Lord Justice Purchase is quoted as saying the crucial requirement for convention estoppel is that at the material time both parties should be of a like mind.
Well, I would say I would certainly agree, my lady, that is, when I say an essential element of it, that they are of a like mind. I would say in this particular case, there was no doubt that both parties were working on the basis that there was an open inquiry into this tax return. Whether I would add the word crucial to it, I'm not sure I need necessarily express a view on that, other than to say that it is certainly an aspect of the arrangement that existed here. If crucial just means that they share a common assumption, then I suppose the answer to that must be yes.
But doesn't the expression of like mind suggest that the parties have both animadverted to the same point? Both have in mind the particular issue which is going to be the subject of the assumption relied upon.
Well, yes, I mean they have to have a shared assumption. In this particular case, the shared assumption was that there was an inquiry open. For example, in the Blindley Heath case, of course, it was the shared assumption, if you like, that both parties had forgotten that there were particular preemption provisions in the shareholders' agreement. So it was sort of they both it had not crossed their mind.
But is it also? So sorry. No, I'm sorry. I didn't want to cut the sentence. Did you want to say something?
No, I was just saying that at Blindley Heath, I think, on the basis that both parties, it was just a case that they both had forgotten that there were provisions in the shareholders' agreement, rather suggests that when I say the nature of what it is you're looking at, it's not necessarily that they both have to be consciously thinking of the same thing. They can consciously, or is it unconsciously, have forgotten the same thing, and yet at Blindley Heath that's regarded as sufficient.
So they don't have to be both focusing on any matter that might invalidate the notice.
No, I think it's more, particularly in this case, it's more a case that they're both focusing on the fact that there is an inquiry in progress. So they've tacitly assumed the fact that Mr. Tinkler has been given the notice.
Thank you.
So I was just saying, my lords and my ladies, that as I say, my learned friend seeks to justify what I say is a rather extreme position about the way in which estoppel by representation excludes estoppel by convention. He says that by an innocent representee might find himself bound to adhere to an assumption that has arisen by virtue of a negligent misstatement made by the estoppel raiser. Now, as to that, I would say that first, it's not obvious why conventional estoppel would not apply in such a case, depending on the facts. Indeed, bench dollar is arguably a case with such a fact pattern. I say it's simply too sweeping to contend that conventional estoppel should automatically be excluded in all cases where the party to be estopped might be able to set up a different estoppel on the same facts. And secondly, my learned friend's example was presumably intended to illustrate a situation where it would be said to be unjust to hold a person to a common assumption. And as I've just submitted, it's not obvious that his example does illustrate such a situation. But in any event, such concerns can be dealt with far more sensibly and effectively through the fact-sensitive application of the requirements of conventional estoppel, and in particular the unconscionability requirement. That by means, rather than by means of an automatic exclusion of conventional estoppel, as my learned friend urges. That was my second point. My third point in relation to this aspect of my learned friend's submissions relates to his submission that it would not be open to Mr. Tinkler to set up an estoppel by representation against the revenue, because the revenue is a public authority, and there might therefore potentially be an imbalance if taxpayers are subject to private law constraints in the form of estoppel, whereas the revenue are subject to public law constraints. As to this, I will simply say that my learned friend is arguing in favour of an imbalance in the law anyway, rather than against one, His position appears to be that whilst the revenue might be bound to honour something said or done by them as a result of the application of public law principles, the taxpayer should be subject to no analogous private law constraints. I say that's wrong in principle, and there's no support for it on the authorities. So that was my first point in relation to what my learned friend says about estoppel by representation. The second element I'm going to deal with in his argument is that here there's no transaction or course of dealing of the right sort. I have 2 points in relation to this. First, my learned friend's argument that a transaction is required is irreconcilable with bench dollar, and such an unprincipled and fundamental restriction on the doctrine has no foundation in the authorities. Insofar as my learned friend can point to dicta where the relevant principles have been discussed in the context of a case involving a transaction, so what? That tells you nothing. The question is whether the principles in question are apt to apply to a case that does not involve a transaction, whatever the scope of that word is supposed to be for these purposes. And secondly, my learned friend's argument that an estoppel can only arise if the mutual dealing in question involves a benefit to both parties is similarly unprincipled and has no foundation in the authorities. As to this, we respectfully agree with the point made by my Lord Hodge in relation to the Grunt case, that it's implicit in what Justice Dixon says that there's no requirement for both parties to benefit from the convention. We also submit that it's clear that there's no requirement for the estopped party to benefit from the convention, because the fifth bench dollar ingredient acknowledges that the doctrine can operate where detriment has been suffered by the person raising the estoppel, or where some benefit has been conferred on the party said to be estopped. That's at paragraph 52, little Roman 5 in bench dollar at page 1244 in the bundle. The present context involves a course of mutual dealing between Mr. Tinkler and the revenue to determine the correct amount of tax that he is liable to pay for the tax year 2003-4, leading to a tax repayment to him of nearly 1 million following the Court of Appeal's decision. It's impossible to see why the relevant principles of convention estoppel should not apply in that context as compared to the context of a contractual dispute, the conduct of affairs of a company, such as Bindley Heath, or the context of litigation arising from any form of dispute, such as Allison and Limehouse. So I say that is without principle and not a requirement of conventional estoppel. My third response to my learned friend's submissions in relation to Keane and Holland, I say these appear to be founded on a new contention by my learned friend to the effect that Section 9A of the Management Act does somehow prescribe the method by which notice is to be given, leaving apparently no room for the revenue or a taxpayer to agree as to how notice might validly be given. As my learned friend appeared to accept, that submission required him to resolve from the concession of law he made in the courts and tribunals below to the effect that it was possible for a taxpayer to agree with the revenue that they could discharge their obligation to give notice to the taxpayer by giving a notice of inquiry to a specified agent. Moreover, my learned friend's new position is inconsistent with both authority and the relevant statutory provisions. It was held in Spring Salmon, at paragraphs 27 to 33, that's a bundle pages 1258 to 1260, I took you to them in opening, that the service of a notice of inquiry did not call for special formality, and there is nothing in the terms of Section 9A of the Management Act which prescribe how notice is to be given. Section 115 of the Management Act, which is at bundle page 645, sets out a means by which notice may be served, but as was held in Spring Salmon, and is clear from the words of that provision, that section is permissive, not mandatory. In short, I respectfully submit that there's no basis for my learned friend's submission on this point. My fourth response to my learned friend's submissions dealing with assumption of responsibility, and on this I have three elements of my learned friend's submissions that I want to address in reply. The first element of my learned friend's submissions that I wish to address relates to his attempt to pour cold water on what Lord Denning said in Amalgamated Investment. I will deal with this point briefly because I'm not sure where this point actually takes my learned friend. However, he did spend some time seeking to dispute the point made in our written case at paragraph 35, that's on page 77 of the bundle, that Lord Cook and Lord Hutton agreed with Lord Bingham in Johnson and Gore Wood. The reason why we say that is because Lord Bingham dealt with the estoppel argument in that case as part and parcel of the abuse of process argument. If one goes to the bundle at page 938, page 22 of the report, there's a heading you'll see, abuse of process. The estoppel by convention aspect is considered under that heading, starting at the bundle page 949, page 31 of the report, letter G, and it's important to note that the argument that Lord Bingham was considering was that Gore Wood were stopped by convention from contending that Mr. Johnson's claim amounted to an abuse of process. That is why it was addressed by Lord Bingham within the part of his speech dealing with the abuse of process issue. Lord Bingham's conclusions on conventional estoppel begin at page 949 of the report, page of the bundle, page 33 of the report, letter D, where he cites with approval what Lord Denning said in Amalgamated Investment. And his lordship's conclusion is that firstly, the action is not abusive, and secondly, that Gore Wood and Co. are stopped by convention from contending that it was abusive. The second main part of Lord Bingham's speech is concerned with whether damages claimed by Mr. Johnson were recoverable in law. Lord Cook, for his part, on page 958 of the bundle, letter D, states that he agrees with all that Lord Bingham says on the subject of abuse of process, which I say must be taken to include the parts of Lord Bingham's speech addressing convention estoppel, which was also concerned with the subject of abuse of process. Where Lord Cook takes issue is in respect of the question of the recoverability of damages, the second main subject addressed by Lord Bingham. The substantive part of Lord Cook's speech is then devoted to that. Likewise, Lord Hutton, in the bundle, page 966, at letter H, states that he is in full agreement with Lord Bingham's speech on the subject of abuse of process, which, as I have shown the court, included consideration of the convention estoppel point. Lord Hutton, like Lord Cook, wished to confine his observations to the issue whether the damages claimed by Mr. Johnson were recoverable as a matter of law. So that is why we say that Lord Cook and Lord Hutton agreed with Lord Bingham's comments as regards convention estoppel, although, as I noted, it's not clear where my learned friend's point takes his case. The second aspect that I wish to address is my learned friend's point made with reference to the Indian endurance case this morning. In his submissions, my learned friend sought to contend that the revenues estoppel argument could only work if the common assumption was that Mr. Tinkler would not seek to set up a defence based on failure to satisfy Section 9A. I say that submission is plainly wrong. The matter turns on what the assumption in question was and what the person to be estopped is precluded from denying. So in bench dollar, for example, There was no assumption that the taxpayer would not take a limitation defence. The assumption was that the limitation period would be renewed or extended. The consequence of being unable to resolve from that assumption was that the taxpayers could not plead a limitation defence. The same is the case here. And a similar point we made about Bindley Heath. The third aspect that I wish to address is my learned friend's submission on reliance. As to this, the first tier tribunal made findings of fact that the revenue did rely on BDO's conduct to their detriment. Those findings were entirely sound and logical, and Mr. Tinkler cannot now go behind them. My learned friend's attempt to pick at those findings this morning amounted to positing counterfactuals which do not reflect common sense findings of fact taken by the first tier tribunal. Had BDO not actively engaged with the inquiry, the revenue would have actively pursued the matter. That was the first tier tribunal's decision at paragraph 159. Bear in mind that the revenue were told by BDO in October 2005 that the cheque had gone missing and that Haybridge Lane was not his address. If you add those facts to a failure to engage with the inquiry, it is with our respectful submission obvious that the revenue would have taken steps to pursue the matter. And as the first tier tribunal found, such efforts may well have corrected the invalidity in the inquiry. And then finally, on unconscionability. Again, I have 3 points to make on my learned friend's submissions. My learned friend's submissions fail to recognise that an assessment of unconscionability is an intensely fact-sensitive exercise, which is carried out by the fact-finding tribunals, here the first tier tribunal. In our respectful submission, the first tier tribunal made no error of law or error of fact which justify interfering with the first tier tribunal's assessment. Particularly key are the following findings. BDO's actions caused the revenue to act differently to how they would otherwise have acted. That's the first tier tribunal, paragraphs 157 to 159. But for those actions, the revenue would have taken steps which would, or at least might, have resulted in the defect in the inquiry being cured. That's paragraph 161, first tier tribunal decision. The revenue's responsibility for initiating the assumption was not relevant because of how BDO acted thereafter. Again, paragraph 161. The first tier tribunal expressed this in terms of interrupting causation. What it meant by that was that BDO went further than the revenue had done in that they wrote to the revenue in the terms which made it clear that they were of the belief that there was a valid inquiry afoot. My learned friend's submissions, like the Court of Appeal, failed to give any deference to the first tier tribunal's conclusions in relation to this fundamentally fact-sensitive inquiry, which in the revenue submission, the first tier tribunal carried out without error. There's no suggestion that the first tier tribunal misunderstood the law or the concept of unconscionability. Its findings, therefore, should be respected. While we accept, of course, that the revenue were responsible for the inquiry letter being sent to the Haybridge Lane address and that this initiated the mistaken common assumption, BDO's actions contributed to, confirmed, reinforced, and perpetuated that mistaken assumption in circumstances where they had just as much opportunity as the revenue to identify that a mistake had occurred and the means to ascertain whether Mr. Tinkler had in fact received the inquiry letter. The revenue could only know that Mr. Tinkler had not received the letter if they were told that. And BDO's continued engagement with the inquiry and the revenue's information request would not have suggested that the letter had never been received. Secondly, my learned friends submitted that where the estoppel raiser is responsible for the initiation of the assumption, it is more difficult for an estoppel to arise. However, as I've already submitted, that point is not consistent with bench dollar, and my learned friend's attempts to distance the present case from that one are without substance. Thirdly, as to my learned friend's submission about the first tier tribunal's finding that Mr. Tinkler and/or his personal assistant in fact knew about the inquiry, it's incorrect that the first tier tribunal did not make any conclusive finding in this regard. It is plain from paragraph 56 of the first tier tribunal's decision, page 192 of the bundle, that the first tier tribunal made a clear and conclusive finding that, to quote the tribunal, before BDO actually responded to the revenue in November 2005, either or both Mr. Tinkler and/or his PA were told by BDO of the inquiry. And why on earth would they not be, given the relationship between BDO and the authority under which it was operating and what it was doing? That was a finding that was open to the first tier tribunal to make. There was evidence to support the inference that there had been some contact between Mr. Tinkler and BDO during the course of the inquiry, as the first tier tribunal explained. It was a finding that the first tier tribunal was entitled to make, and it cannot be disturbed in my submission. The relevance of the point is that, having known about the inquiry, either personally and/or via his agents, it's difficult to see how it can be said that it would have made any difference to Mr. Tinkler, given all that transpired, that he actually received the inquiry letter in his hands. It was a technical defect that would not have made any practical difference to Mr. Tinkler at all. Those, my lords, are my submissions in reply, unless there's anything further with which I can help you.
I don't see any further questions emerging. Thank you very much.
Thank you, my lord.
Well, it only remains for the court to thank counsel for their careful submissions, and also to thank those who have assisted in the preparation of the documents and the virtual bundles with which we now work. The court will take time to consider this matter, which clearly is of some importance both to taxpayers generally and to the revenue, and we will produce a judgment in due course. The court will now adjourn.